All right. Well, Ian, today we're going to talk about planning for the surviving spouse. And it's often the most difficult of the scenarios to plan for. It can be the easiest or the most difficult. Any opening remarks about this before we dive in and
Yeah, I just had a couple of observations. Number one is that you've always described there's only two ways to give away something, and it's either outright or it's through adding the word "but." And surviving planning for the surviving spouse type of planning is probably one of my favorite buts. If you're going to get into the trust world, because it's a tool that can be, it's an effective tool for a variety of reasons, but it can be easily explained to the client. And if properly drafted, it's a really, I would say, a relatively cheap way of resolving what can be a very sticky estate planning problems with some of your clients. And the last part I'd just say as an opening comment is that underlying drafted properly. We have seen too much litigation. The Balaz estate, some of the other leading cases on this, where the slightest word change here, CRA hovering over this language and wanting to make sure that it's done properly, or they will look for the deemed disposition to occur, which we'll talk about in a second. But the drafting is so crucial and needs to be done so carefully in the sense of map on to whatever language is working, and be careful about making any significant changes to your drafting language for fear of scrutiny at CRA to say that you have not properly done this and you're going to affect the tax trigger. So those are my two thoughts. It's one of my favorite butts and my favorite, but the drafting piece of it just needs to be carefully attended to.
Great. So part of the idea of this session today is not so much about, well, partly about us as lawyers, but also how to communicate with the clients about this scenario. So this is the scenario where the spouse survives you, and what are you going to do? And I'm a big believer in trying to limit options and put them into choices for clients. And in essence, there are three choices that I give my clients to think about. The first is, do you want to leave everything to the spouse? Absolute. The simple approach and the fact that the surviving spouse can do whatever he or she wants with it. We'll get into that in a second. The second is the use of a trust. And the third is carving out something immediately, even if your spouse is alive, to the kids, for example, to a third party. So those are the three options that I typically show clients, and then I go into them in a little more detail. And the first one is this everything to the spouse absolute. And this is, Ian, maybe you can address, the risks of not explaining this option, especially in a blended family scenario. You're on mute. It's 1-0, Jordy.
I hate it. Yes, for sure. And this is really the triggering one. In a blended family situation, the spousal trust arrangements make a lot of sense because it protects the structure of the asset flow. If it goes absolutely, and in this item number one, if the asset goes absolutely, then of course, the surviving spouse then can do what he or she wants with that asset. And that's all sort of naturally intuitive to us to know, understand. But the next step is, of course, making sure that the surviving spouse and the existing spouse, when they're giving their instructions, understand that you've lost complete control on your passing. And of course, all of the assets could go to in a way that is not what you anticipated. And the last thought on that is that, most of my clients in that situation are saying to me, "Well, I trust my surviving spouse in that scenario," and there's nothing wrong with that. And so I don't think today's purposes is to say that spousal trusts are for every will arrangement, because lots of times you can trust your surviving spouse to live a life, a fair and safe life, and with lots of access to assets, but at the same time do the right thing on his or her death. But that's the big twist. And in a blended family, of course, there's a tremendous risk that this is going to end up weighted too heavily on the surviving spouse's kids as opposed to the first to die's case.
Right. And so the only point I always like to make is that, they can go and they'll give it to their new spouse, right? Are you okay with that possibility? And I just give it to them as bluntly as I can. And most of the time, in most cases, this is exactly what, especially in a first marriage situation, is exactly what they're going to decide to do. The second option, and as you've said in the opening, I always say to clients, there's only two choices. One was that absolute gift, and the only other option is called a trust, and you need a trust if you use the word but. So if you say, well, I want to give it to my spouse, but when they die, I want to make sure my kids get it, then you've just described the need for a trust. And that's how I put it to my clients. And this is a slide that I show my clients. So this is not so much for the lawyer, but for the client to understand, okay, how does a spousal trust work? And these are sort of the rules. You can do it with an asset, you can do it with a specific amount, you can do it with a percentage, of course. But the key is it's got to be held for the rest of the surviving spouse's lifetime if you want the tax benefit. And we'll talk about that in a moment. So this is sort of the outline for the client, and we're going to get to that in a moment in more graphic way. And in fact, maybe what we'll do is turn to that right now. So this is for us, okay, as the lawyers to remember that the reason we want a qualifying spousal trust, as Ian has said, is to avoid the deemed disposition of capital assets on death. If we don't care about income tax deferrals, then we don't care about it being a qualifying spousal trust. But in most cases, we are concerned about deferring the tax until the second spouse dies. And so what we'll want to make sure is that it's a qualifying spousal trust. Ian, do you want to take us through maybe the first issue there?
Well, that's it. And then that's the one where one of the leading cases came out of. This is this idea that the language has to expressly say that the surviving spouse is entitled to all of the income, and that the rules in that regard can't be loose at all. It can't allow for as you've identified, stopping the income. It can't allow for sprinkling of income to other beneficiaries. All the income to the surviving spouse. And again, coming back to the drafting, look for that language.
And the third one, we talked about the first one being, you can't stop this trust at some point other than the death of the second spouse, or it won't be a qualifying spousal trust and therefore won't be eligible to defer the capital gains. And so, this is where there's a sticking point often is, a client will say, well, I want to hold as long as the spouse is alive, unless they remarry, and then I want this to go to the kids. Well, we can't do that and have it as a qualifying spousal trust because 1 and 3 tie in. 3 is that no one except the spouse can access the assets in the trust until the spouse dies, the second spouse dies. And so that's the key. You can't say, oh, by the way, we'll keep this trust until you remarry and then it goes to the kids. No, can't do that. It won't be a qualifying spousal trust. It'll be a non-qualifying spousal trust, or what's also known as a tainted spousal trust. And there's some key factors, and this is where the cases go as well, Ian, on number 3, which is, sometimes we put in, you'll have a precedent that you don't change and you'll inadvertently taint the spousal trust. How could you do that? Well, the first one is you could say, you could include a lending power to someone other than the spouse, which you can't do except on commercial basis. But that's a situation where you can inadvertently taint the trust. You can allow for the waiver of income that might terminate or taint the trust. You could say pay life insurance premiums out of this trust. That would also taint it. It's so very technical. And I'm no tax expert, and I know, Ian, you're not either, but we have to be so careful about what we do in a qualifying spousal trust.
Yeah, and again, I always circle back to this. Lots of families, depending on their assets, there's going to be some rollover anyway to a spouse. So a qualifying spousal trust may be overkill for some planning scenarios. But this planning scenario, of course, accommodates the second family concern that if you have some wealth and you're going to pass it on, that if it's put in a properly qualified spousal trust, then you're protected for that second generation to enjoy the gift on the death of the surviving spouse.
So I don't know what happened here, but this is what I show the client, because I'm not a bigger believer in pictures than words. And this is how a qualifying spousal trust would work. We have the principal, of course, right? Whether it's a percentage of the residue, the entire residue, a specific asset, or a specific amount. And we know for a qualifying spousal trust that the income must all be paid to the surviving spouse, okay? Entitled to all of the income. And then we know who the ultimate beneficiaries are. This is really the reason in most cases that we're using a spousal trust. It's because we want to preserve whatever's left over to go to some ultimate beneficiaries and not allow the surviving spouse to pick those people. So that's fine. But just remember, of course, that the ultimate beneficiaries can't access any of the principal or income during the lifetime of the surviving spouse. And then we have what I describe as rules that the client can create about how money is going to flow out to the spouse during their lifetime. So the first one, mandatory payments, we know that there has to be at least one mandatory payment if it's going to be a qualifying spousal trust. And that's the mandatory payment of income, all of income. The second option for mandatory payments that's often used is a minimum. So you might say, look, I want to make sure my spouse gets at least 100 grand a year. So he or she gets the income, but if it's less than 100 grand a year, top it up from capital. That I would consider a mandatory payment. Do you want to just describe, Ian, the use of an unlimited sort of discretionary power for the trustee on capital encroachment?
Yeah, and this is the clause that's most often used in my experience, and that is the trustees can give as much of the income and capital as within broad discretionary powers to the surviving spouse. And the limit on that is an old case called Gisborne and Gisborne, where the court said, look, as long as you're acting as trustee in a bona fides way, and there's no mala fides, there's no ill intent in terms of your exercise of discretion, then the broadly described language in a power to encroach like this is something that is essentially unlimited. And I think in the right situation, the right balancing tool to make sure that your surviving spouse is going to have as much money as they see fit in many respects during their lifetime, but keeping the benefits of the tax piece of it. And remember, and I always tell my clients, at the end of the day, we're the biggest law firm in Canada that does estate work, and we're 20 lawyers. Most of the time, this stuff works. And so if you get a situation like this and the client goes, well, what about if I want to give money to my kids as I grow older? And you say, well, look, if you've got a broad power to encroach, you take the money out yourself. The surviving spouse takes the money out themselves. They can do what they want. They can then gift it on to their children if they see fit. So it's not as though you're completely locking out ultimate beneficiaries or children by creating these tools. You just have to have it in the right spot, pull it for the right spot to the right person, and then you have the right, of course, to do what you see fit with the money.
The other key element there, of course, when you give unlimited discretion to a trustee is who's going to be the trustee. And that's what makes spousal trust difficult in many ways. You could, of course, name just the spouse as the sole trustee of their own trust, in essence. And I always describe that as, a spouse would ask themselves, can I take some money out? And they always say yes to themselves. The other option is to put someone else in charge, either with the spouse or somebody else. And then the spouse has to go to that person, though, and say, can I have some money, please? And that's not the greatest dynamic. And often, once you've described that to a client, we start looking at option 3, which I'm going to get to in a second. The other thing you could do is you don't have to, in a qualifying spousal trust, provide for any power to encroach on capital. There's no requirement that the spouse have access to the capital. They just have to get all the income. So that's one option. It's not flexible, but that's a possibility. And then there's what we call limited powers to withdraw principal, or encroachment powers as we all know it. You could put all kinds of rules in there. You can make, and you can customize them, but, to a maximum amount per year or annually, or only for specific purposes, or stop capital encroachment if they remarry. That you can do. That's perfectly fine. You just can't give it you can't give it to anyone else during the spouse's lifetime, and the spouse has to get all of the income, but capital can be more flexibly used. So that's that. I'm going to defer dual trust planning for a second. Ian, sorry, did you have a comment?
Going to say, just coming back to when we do these spousal trusts, that your last chart has such a great, that's just a great checklist. Okay. And there are things to make sure that, just because just say spousal trust, power to encroach or not. Well, no, you can go further and ask the good questions about, well, what about, tailoring it to your circumstances instead of just throwing the whole concept away because you don't want unlimited access to a spousal trust, because that's what a power and encroach does, because you want to just give your spouse the role of trustee. Then you say, well, okay, let's talk about how we tailor it. And well, what are some of the questions that we need to ask when we're going to tailor it? And Jordy, you're just going to tell us how you would go through that.
Yeah, no, I just wanted to demonstrate when those questions come up. So here I just clicked on created a spousal trust, but this is a qualifying spousal trust because it's going to run until the death of the beneficiary, the spouse. Payment of income is going to be required. But talking about discretionary payments, we could choose limited. And for example, we could build all kinds of, here are common ones, to limit the encroachment, so that, only if the client has used up their own assets can you dig into the principal. And you can set some more rules about that, but, annual limits are only for a specific purpose. So this is a good checklist to do that. The other good thing is, let's say I screw this up and the client says to me, you know what, they get all the income, but if they remarry, it terminates. They stop getting the income. And I just mark that down. The good news is that if you use software, it's going to trigger this warning that says, just so you know, this is non-qualifying. We have a tainted trust here. And this is a key piece of advice. So it may be that the client wants to do that, and that's fine. I would definitely obtain an acknowledgement that the client recognizes this is a non-qualifying spousal trust, and there won't be a deferral of income tax, right? So I just wanted to demonstrate those impacts.
That's right, and it's a good checklist, but it's also a good double check when you go to the advisor alert. Just on the one point, and it's something that often we forget, is there's strong case law. I mean, it's case law, but there's strong case law that says that in the situations where it gets contentious after death and the surviving spouse starts saying they're not getting enough money out, maybe they've got a trustee they're not getting along with or something, there is authority for the proposition that the court isn't even allowed to find out what assets the surviving spouse has. And so, sometimes people lull themselves into thinking, well, the spousal trust is a great idea because, she's already got lots of money, so she's not going to go at it. And it's all going to be there for the capital beneficiaries, and everything's going to be great for the capital beneficiaries. And then they stop paying the surviving spouse, and then the surviving spouse says, you don't get to see any of my information. I want the money, and you have to act in a fiduciary-like fashion to pay me the money. So anyway, it's just sort of an important red flag I like to identify in the course of this, and it comes right up when you do that checklist that Jordy showed us.
Yeah. So let me then go to the next slide. Oops, I'm just going to go to, we'll get to the wording in a moment, but let me just do that. So let's just skip over dual trust planning for a second and go to this third option. Remember, we talked about option one is everything to the spouse, absolutely. Option two is some use of a spousal trust for part or all of the estate. And the third is, the client says, I don't want my spouse to have to go to some third party and ask them for money and all of that. And I don't want them to have, I want my kids to be getting something. So I'm going to carve out something immediately, even if my spouse is alive. And that way I know that my kids are at least going to get that if my spouse decides to cut them out at the end when they make their last will. And so the benefit of this is, you might not have to use a spousal trust. You ensure that the children get at least a basic amount. We typically like to use life insurance because it's tax-free. It kicks in when you die, and so it's available for the kids to get. And so if that's a possibility, if there's excess life insurance that the surviving spouse is not going to need, well, then that's a great, and you want to provide it to the kids, that's a great hybrid. And of course, you can combine all of those three options: absolute, trust, and gifts to children in the plan, right? It's not all one or the other. So those are the three that I wanted to talk about. I just want to briefly touch on we talk a lot about qualifying spousal trusts, and they're great to defer tax, right? That's what they're there for. But it's not that you need that necessarily in every case. You may have a lot of assets that have no capital gains that will be triggered on death. And rather than put it in the sort of unflexible or inflexible spousal trust that, doesn't allow money going to anyone other than the spouse and all of those other rules, you can have more than one kind this for the spouse. And this is classic dual trust planning. Ian, do you want to describe that?
Yeah. And it's this type of planning came out in the old Wolf Goodman days. He was one of the leaders to create this. And what it allows for is you create a spousal trust, and then you create a spouse and children family trust, we'll call it. And so, and then in the will, you say that the state trustees will make the decision as to the allocation. And you typically will have the surviving spouse as one of the estate trustees, of course, not of course, but typically. And so they'll have something to say, but you might put $1 in the family trust if it makes tax sense and personal circumstances sense to put $1 into the family trust and $10 in the spousal trust. But you might go 5 and 5, you might whatever. I just come out of a very, very big estate administration and litigation that we had to make this tough decision. And we were in the middle of litigation even, and we made this tough decision as to how to allocate between the spousal trust and the family trust. But the estate trustees did a judicious determination, got tax advice, and made the tough decision as to how to allocate. But this dual trust planning, giving the trustees the choice to allocate, is a really good flexible tool in the right circumstance.
Right. And the benefit, if you had it all in the spousal trust, of course, the kids couldn't get access to the money, or the trustee couldn't give any money to the children during the lifetime of the spouse. But with this flexible trust, they can sprinkle, right? And so what typically happens is any assets that would trigger capital gains on death go into the spousal trust. It's deferred, and everything else, GICs, bank accounts, anything that are, fixed income, would go in the flexible family trust, which could also go to the spouse, but the spouse is just one of multiple beneficiaries. So that's some other planning. And I just want to briefly address a couple of questions that we have. And I also want to show we talked a little bit about the wording. So I wanted to just show the clause that you should include. And of course, this is eState's wording, but anytime you're lending money or you're allowing the power to lend money, you want to make sure that you've ousted the possibility that they could lend money and taint the spousal trust. And so that's something we discussed, and I'll show you that actually, because what I did, of course, is I just generated a non-qualifying spousal trust. But remember, if you recall, I tainted the spousal trust by saying that the income stopped on remarriage. And so that would obviously be a non-qualifying spousal trust. So I'm going to make sure that I don't do that. And I'll get that. I took that advisor alert, and now it is a qualifying spousal trust, thankfully. So I don't have that warning anymore. And I'm just going to generate the document so I can show that to you. In the meantime, wanted to address a couple of questions. It's just going to take a couple seconds to generate the document. But so a question is that, can you disentitle a spouse from receiving any of the capital in a spousal trust? And yes, you can. They don't have to get any of the capital, but the income they must get. Common law partners do qualify for spousal trusts. That was another question. There's typically no requirement to allocate a specific amount, unless the will says differently, specific amount to each of the different, in the dual trust planning. You have to put it starts with $1, but after that, it's pretty much discretionary. Ian, can you address mutual wills while I just open this up? And we only have a couple of minutes to deal with that. Do you love multiple mutual wills? Do you like when people do mutual wills? What do you say?
On the litigation side, I love them. But look, at the end of the day, we could spend a whole half hour or more on the whole concept of mutual wills. I think that the difficulty is this. They're not a proper planning tool to use. And the spousal trust tools that we're talking about today are. And it comes down as simply as that. And that's my personal view. And a mutual will is a planning disaster in most cases. So, but I'm hesitant to get really too deep into that because we want you to focus. Well, I want to focus on one of my practice I'm using. If I'm in a situation where I want to preserve wealth and I've got some concerns about the second step, i.e. the surviving spouse is getting it out, absolutely. It's a mutual will arrangement can only be done by contract, and it gets more complicated than it's worth. And this kind of planning for most individuals is the most direct way of solving that problem. So Jordy, over to you to talk about the language.
Yeah, so this is a spousal trust. You'll recall we said we were going to restrict capital to only if the spouse's financial resources were exhausted or insufficient. And so this is the kind of typical language that you could go in and amend if you wanted to, if the client wanted you to, but this is the sort of language that you might see. And then the other thing I wanted to show was the restrictions on lending and things like that. So what we do is if eState sees that you're doing a qualifying spousal trust, it will automatically insert this language that then restricts certain of the powers so that it doesn't taint the spousal trust. So it now inserts this subject to, and you'll see this paragraph is even, notwithstanding anything in this will, nothing in this will is to disqualify a spouse trust. And so if you read this, do not read it so that it allows for the tainting of a spousal trust. And this is language that's pretty typical. And so that's how we address that. And you'll see that in any good precedent that will amend the regular powers to make sure that you don't taint the spousal trust by including a power that would otherwise do that.
And that language has been heavily tested too. So it's...
Yeah. And that, folks, in a half an hour, takes you through, and I'll just get rid of this for a second, takes you through the options for dealing with, I'll just go, sorry, that's the mutual wills issue. We will make the slides available. I use these slides in my meetings with the clients. They grasp it quite easily. And it's an easy way to limit the number of decisions that a client has to make. You can break it down. And so feel free to use our slides from eState Academy. And Ian, thanks again for another great session. I really appreciate your contribution. And if there are any other, there's Ian and Jordy, can you provide recommendations for your favorite resources on administrative clauses and wills? I say eState, but that's...
Absolutely. But, I would say, all of the texts are excellent, right? I mean, Peg Rintoul's got a great one, Armstrong, they're all excellent. It's just, the problem is that old school way of dealing with the documents is cumbersome. And, from my perspective anyway, you're not finding, Lindsay Histrup's got an excellent book. They're all excellent. It's just, you got to pull out of the book. It's all old school. It's hard copy.
Well, thanks everybody. And I hope to see you again next week.